Welcome back. This is Federal and Indian Gaming Law. Today we're going to talk about the internet again, UIGEA or UIGEA, and court opinions are going to be the focus of today's presentation. Again, sort of a recap. Don't forget the things we learned in the beginning of the class. That'll come in handy again today. And hopefully you remember about the networking discussion we had on Monday of last week. Again, the internet, a TCP/IP-based interconnection of networks, operates on packet switching rather than circuit switching, which means the network connections are persistent. It's not like the old days when you pick up a telephone, you dial a number and a circuit would be created between you and the person you were calling. Now, information is broken up into packets, sent through the internet, through that using that TCP/IP protocol, and arriving at each destination nearly simultaneously, like we're doing right now. No borders, which is a little bit of a misnomer. You can set up borders with routers, but it's pretty difficult in a modern society. North Korea has borders. United States, not so much. And it's self-healing, which means that if any part of the network goes down, it doesn't disturb the network as a whole. So those packets get routed from origin to destination and back, even if there are breaks in the network, because they'll just find a different route to get there, which makes things difficult. It makes things difficult with things like laws. Laws are inherently geographic. And we have Nevada state law, we have Clark County ordinances. Clark County ordinances are applicable in Clark County, and Nevada law is applicable in Nevada, and US law is applicable in the United States. And, as you can see, laws are border specific, geography specific, but this network is not. This network is international in nature, and it really knows no borders. So with that backdrop, let's talk about the UIGEA again. Again, the background, this occurred in 2006. The law was enacted in 2006, but it had failed in 2004 and 2005 to become a law. The bill had very little support, and it was up against a big lobby from banks that really didn't want to see this law passed. But the timing was interesting. So it's 2006. It's an off-year election. The party that was in power in Congress had an issue with a lobbyist tied to the party that was also tied to online gambling interests. And they decided they were really going to do something about it and promised the American people they'd do something about it. And now it's the last day of the session. It's in the late evening, and Senate Majority Leader realizes, hey, we haven't crossed this off. And by the way, Senate Majority Leader at the time was Bill Frist, who was, at least according to the betting sites in the UK, the most likely Republican nominee for president in 2008. Now, it didn't turn out that way, but he really wanted to get this done. And so sometime after midnight in September in 2006, he found, I believe it was Jim Sensenbrenner from Wisconsin, who was willing to put it on the Safe Port Act. So it gets attached to the Safe Ports Act, which is a bill to fight terrorism, and it would require ports to install fissile detection equipment and to run each container through that equipment to make sure a dirty bomb or a nuclear device didn't make it into the United States through a shipping container. Now, the port industry wasn't too thrilled with this. It's expensive, it would slow down everything. And so it became more of an advisory bill. And then the UIGEA got stuck on the back end of it. And again, last day of the session before you're going to go out and campaign. It's 2006, you're 5 years removed from 9/11. It's an anti-terrorism bill. Who's going to vote against that? if I were in Congress, I could see myself saying, seeing the ads already. Greg voted against an anti-terrorism bill. He is for terrorists. So nobody voted against it. And it becomes law. And the first thing to note about it is the rule of construction. And this is really, really important. No provision of this subchapter shall be construed as altering, limiting, or extending any federal or state law or tribal state compact prohibiting, permitting, or regulating gaming in the United States. And this is important because this is not a criminal gambling statute. It's often cited as one, but it is not. It's a Title 31 statute. Title 31 is where we find our Bank Secrecy Act laws and banking laws. So it is a financial services law. So again, with that rule of construction, does it actually make online poker illegal? No, it relies on other laws to determine whether particular activity is illegal or not. Now, in 2006, online poker was really hot. You had 3 companies that did initial public offerings on stock exchanges in the UK. Those 3 companies had their primary source of revenue coming from the US. Party gaming was the biggest by far. But after the UIGEA is enacted, all 3 of the publicly traded companies pull out of the US saying, well, the UIGEA now made poker illegal, online poker illegal in the United States. That's not entirely true. In fact, it's not true at all. Because the UIGEA relies on other laws to determine whether an activity is actually gambling or not. So let's take a look at some of the definitions. And you should find this interesting. So a better wager has 2 definitions under the UIGEA. The first one says it means staking or risking by a person of something of value upon the outcome of a contest of others, a sporting event, or a game subject to chance upon an agreement or understanding that the person or another person will receive something of value in the event of a certain outcome. So I kind of highlighted that language, subject to chance. What standard do you think that is? Kind of thinking back to our first couple of weeks. Any guesses, Courtney?
I cannot remember like the names of the standards off the top of my head right now, but I know that there was one that was like if it had any portion of chance, it was a game of chance.
Any chance or material element test? That could be. Would really make this a very, very broad statute. But it becomes interesting because there's also a second definition. There's a part B. It says it includes the purchase of a chance or an opportunity to win a lottery or other prize, which opportunity is predominantly subject to chance. Anybody take a guess at what test this is? Alex?
Is this the dominant factor test?
Yeah, it is. Now, that background about how this was enacted is important because there were versions of this bill that failed where it said predominantly subject to chance in both A and B. But that's not the version that was ultimately passed. It appears, anybody familiar with how Congress kind of works, pages, assistants, things like that? I mean, do you think Bill Frist actually went around and found the last and best copy and handed it to Congressman Sensenbrenner and had that well vetted at, I don't know, 11:30 at night on the last day of a session? My guess is that they sent somebody, he told somebody in his office to get a copy, who then told somebody else in the office to get a copy, who then told somebody else to get a copy, and they went and got a copy, but they didn't actually get the last and best version. So you end up with subject to chance in A and predominantly subject to chance in B. But that's what gets enacted. What does it mean in A? Anybody's guess. Don't know. Could be the predominance test, but there's an argument that it's not because they wanted it to be the predominance test or the dominant factor test. They would have said it. Clearly they knew about it because it's in B. Alex.
Just a question. So outside of like the differences in how they characterize like the level of chance between the like subsection A and B, is there any difference between like what activities may be covered based on like the other words that are used in these subsections? Because obviously, you know, they're different. I can imagine there would be some wiggle room. It seems like A is much more broad than potentially B might be.
Yeah, B was really supposed to get at lotteries, and particularly cross-border lotteries. A was supposed to be the, you know, the general contests. And again, I don't know what went on, but you would think you'd want the predominance language in A rather than B if you were going to make a mistake. But that's just me. It is what it is. I mean, that's what the statute says, and that's what we're left with. Courtney.
Do you know how this has been applied, like how courts have interpreted this?
They haven't really had an opportunity to interpret it much. There haven't been, well, we'll get to the only really UIGEA case a little bit later on, but it was a constitutionality challenge, and I think it was a disingenuous challenge to begin with. But no, the courts haven't come down on it. How this is going to come down is anybody's guess. Again, because it happened after midnight, last day of the session, no debate. The congressional record, the legislative history is pretty empty. There just isn't much there. This was a pure political move. I mean, what does online gaming have to do with port activities? The answer is none that I can think of. So it was there to support the American values agenda that was on the table at the time. But it got tacked on. Nobody votes against an anti-terrorism bill on the last day of a session before you go campaigning for another month to either, to hold on to your seat in Congress, or for the third of the senators to hold on to your seat in the Senate. So no discussion, just comes up for a vote. It was an amendment made at the last minute, and it passed. So what about things like checkers? You know, would those be considered a bet? You know, if you bet $10 against somebody playing checkers, that be deemed a bet or a wager under the UIGEA? Courtney.
Doesn't it depend on if you're going with like section A or section B?
Yeah, I mean, I don't know. Exactly. The same thing for Tetris and trivia contests. You know, and there are some big companies that do small wager skill gaming. I think Electronic Arts has a site. They've got a lot of casual games like this, checkers and Tetris and trivia contests. You know, it's just 25 cents to play and you win a little bit of money. Nothing major. But yeah, it makes it interesting. There are some exemptions to the definition of a better wager: securities trading, indemnity agreements, insurance contracts. We talked about indemnity agreements a little bit last time. We're covering this again because I kind of sped through it. Again, participation in a game or contest where the participants don't stake or risk anything of value other than personal effort. So that contest we learned about in the Seattle Times, where you don't have to buy the paper to play, would that be deemed a better wager under the UIGEA? No, probably not. Does that mean it's exempted under federal law? No, it doesn't. You still have the Unlawful Internet Gambling Enforcement Act, which relies on state law. So you could still be engaged in the business of betting or wagering for something that is exempted under the UIGEA. It just means that you won't face UIGEA charges in addition to the Illegal Gambling Business Act charges. And the big one. The fantasy sports exemption. Now, again, at this point in time, 2006, there was no such thing as daily fantasy. Fantasy at this point was a popular office game. When I started practicing in 1999, I was working primarily with an attorney that was pretty protective of anybody doing work with me other than him. So I thought, got to find a way to meet the other people in the firm. And there was a fantasy football league, so I joined it. And it was a great way to meet other people in the office. And it really was. It was an office pastime. You know, not real big money or anything. And it took a whole season to play. And at the time, back in 99, none of this was online. So you had to go through the RJ on Monday and Tuesday to get the statistics. And, you know, you'd email the commissioner the scores. And if there are any disputes, the commissioner would resolve them. But it was primarily an office activity. It was de minimis. And it was popular in offices in Congress too. In 2010, I was working with a client lobbying in DC on online poker issues. And our resident lobbyist in DC was having trouble getting an appointment with a certain senator. So he called the office and told the senator's secretary that to let the senator know he was proposing a trade. He was willing to trade Adrian Peterson for somebody. And immediately we got a call back. Trade gets done, and we got our office visit and some time with the senator. So this was popular. It was popular in offices, popular in work environments. It was seen as de minimis. There was no fantasy sports industry at the time, and the UIGEA exempted it from its prohibitions. Again, doesn't mean it's legal under state law or under other federal laws. Just means that there's not going to be a UIGEA violation if you meet these criteria. And the criteria are pretty simple. Prize has to be known up front. The winning outcome has to be reflective of the knowledge and skill of the participants. And it's determined by the accumulated statistical performance of individuals and athletes in multiple real world or sporting events or other events. Can't have players from the same team, and it can't be based on performance of a single athlete. Pretty basic. So what does the business of betting or wagering mean under the UIGEA? Well, it means, well, don't know what it means, but we know it doesn't include financial transaction providers or ISPs or telecommunication companies. So in-ray MasterCard, not going to apply here. We're not going to hold the financial transaction providers liable under the UIGEA for online betting activities. Same thing with your ISP, Cox or whoever, or telecommunication services. So what does unlawful internet gambling mean? It means to place or receive a better wager. Remember that big definition? And the exemptions. By any means which involves the use, at least in part, of the internet, where such bet or wager is unlawful under any applicable federal or state law in the state or tribal lands in which the bet or wager is initiated, received, or otherwise made. So it relies on other statutes to determine whether the underlying activity is actually betting or not, or wagering, or gambling. And that's why this is not really a criminal gambling statute. Again, you have some exemptions, you know, wagering, you know, interstate wagers where the wagering is legal, provided there's appropriate data security and age verification. Intra-tribal transactions. So tribe can have multiple bingo halls and connect them up through internet transactions. Bets placed in compliance with the IHRA, the Interstate Horse Racing Act, also exempted from this. So what does it prohibit? Well, prohibits anyone in the business of betting or wagering. So again, supply side only, excluding credit card companies, excluding ISPs, excluding telephone companies or telecommunication companies. No person in the business of betting or wagering may knowingly accept in connection with participation of another person in unlawful internet gambling. And then there's a laundry list of things they can't accept. It's really anything of common value. Checks, money, ACH, credit card transactions, other valuable financial transactions. So a whole laundry list of things that you can't accept. And if you do, you're violating the UIGEA, but you already have to be in the business of betting or wagering. So again, it only applies to the betting sites. The other provisions are regulations to make financial organizations the enforcers of the statute. And this is why the banks didn't like it. Banks didn't want to have to be the enforcers. And how did the banks become enforcers? They are supposed to identify and block transactions that fund unlawful internet gambling, which means they have to change their computer systems to do that. If they do that in good faith, even if they block transactions that are not illegal internet gambling transactions, they have no liability. So they will err on the side of blocking transactions. Now, this gets passed in 2006. It gets enacted in 2006, becomes effective in 2007. Anybody remember what happens in late 2007, 2008? It's sort of a financial meltdown in this country. Big one. Credit default swaps, the economy kind of melts down, and a lot of banks become insolvent. So regulations didn't actually weren't enacted until the very last day of the Bush administration in 2009. Remember, there was an election in 2008, but you know the new president doesn't actually take office until late January 2009. In late January, the day before that, the regulations were put in place. They stalled it as long as they could. So let's take a look at some things. This is the Montana fantasy sports law. Oh, Courtney, question.
Yeah, I'm just wondering why the Bush administration stalled as long as they could on the regulations.
Because banks were in bad shape. And banks were lobbying heavily to not implement
Like they didn't want to take this on.
exactly. I mean, they were struggling to stay alive. They certainly didn't have money to spend on brand new computer systems to identify and block transactions that might be gambling transactions.
Okay, makes sense. Thank you.
Sure. Yeah, it was not, you know, they and they weren't happy with this. And again, the way it was enacted, they really didn't have time to lobby against it. It was just tacked on to the Safe Port Act. I don't think anybody was paying attention to the Safe Port Act. And it happened so quickly. Nobody knew, you know, a lot of people didn't even know it was there. A lot of people in Congress didn't know it was there. So again, it's a flurry of activity that last day. And everybody's focused on getting back to their home districts and home states, to finish campaigning, because you've got a month left. It's the end of September, you've got October, and that first week of November is the election. So, yeah, banks were not happy. And they really weren't in a position to do anything at that point in time. But the Fed did pass, there were, you know, Treasury passed its regulations, and they were enacted the day before President Obama took office, last day of President Bush's administration. So here's a Montana statute for fantasy sports. You know, it's limited to the number of people. Let's see, a league is eligible, a roster is eligible. Let's move on to the next part of this. Fantasy sports leagues are authorized in Montana, but it's unlawful to conduct those over telephone or internet. So you can have them in offices, you can have them in bars, but you can't wager on fantasy sports leagues by telephone or the internet. So if you have an online fantasy sports site, what are your risks if you offer betting in Montana? Federal gaming law risks, at least. Does the UIGEA now exempt this? Does it preempt state law? Doesn't preempt state law. It expressly doesn't preempt state law. So if you're doing it online and it's crossing state lines and it's violating Montana's gambling statutes, and you've got 5 or more people that own, manage, finance, direct, or conduct the activity, any risks you can think of? Maybe illegal gambling business act risks? Five or more people that own, manage, finance, supervise, direct, or conduct an illegal gambling business. An illegal gambling business is one that operates in violation of state law and interstate commerce. Has 5 or more people that do any of those things and either makes more than $2,000 in a single day, or it's a continuous operation for 30 days or more. Now, you won't get the UIGEA charge on top of the Illegal Gambling Business Act charge, but you may have other issues, as you know, you saw with the poker indictments. Because what are banks likely to do? Likely to block the financial transactions, which means you're going to have to code them in a funny way or create a roundabout system for getting funding, which then may violate one or more banking laws. So, wire fraud charge there too. But that's just an example. And again, payouts here, you have a limit, limit on what the league can make, take out. It has to be done pari-mutually. It has to use a pari-mutual network in Montana. So Montana's got a lot of laws about this. Now, if you look at any of the fantasy sports sites, they don't carve out Montana. We'll talk about that when we get to fantasy sports. So, what does the UIGEA actually prohibit? Receiving funds in furtherance of unlawful internet gambling. What is unlawful internet gambling? Anything that is illegal under federal law, state law, or a state tribal compact. There are exemptions from the UIGEA for certain activities, but that doesn't make those activities legal under other laws. This does not preempt any other law. So does it make online casino wagering illegal? No. Make funding skill gaming illegal? No. And certain fantasy sports are exempted from this law, but not from any of the other laws. And again, you've got those regulatory provisions. Now, the UIGEA was challenged by the Interactive Media Entertainment Group Association, UIGEA. They challenge everything. Take a wild guess at who UIGEA is made of? Yeah, online poker sites. Good guess. Yeah, it's all the offshores. I shouldn't say all the offshore. It's a group of offshores, offshore betting sites. And anybody remember the basic facts? Well, this is a group, represents various offshore gambling sites. They filed a debt relief action against the United States, saying that the UIGEA is unconstitutional. Now, anybody, have an idea if these sites are making any money? Yeah, making a lot of money. And in 2006, did they have any legitimate competition in the United States? No, they didn't. So I wonder how genuine the suit was. So they claim that it's a violation of the First Amendment. And we'll talk about the First Amendment on, let's do that Wednesday. So the reading materials are up for First Amendment and free speech and advertising. Go over those for Wednesday. No, this is not a violation of the First Amendment. The First Amendment does not protect criminal activity. It doesn't protect speech promoting criminal activities. Therefore, that First Amendment argument doesn't hold any water. What about it being overbroad? Because the argument is that it doesn't actually tell you what illegal online gambling is. Courtney.
I think it's probably a better argument than the First Amendment. But also it's not supposed to tell you what is illegal. Those are in other laws.
Right.
But you could argue that like because of the contradiction in Section A and Section B, there's like some vagueness or something.
Yeah, you could say there's some vagueness there. The court said it's not overly broad and vague as to be unconstitutional. You could make an intelligent assessment of what's illegal under that act. It gets appealed and appeals court upholds the ruling. Privacy rights also. Does it violate privacy rights in the United States? No. And on top of everything else, UIGEA lacks standing. Which they do in all their cases. By the way, for a while, they were suing the federal government on every federal criminal gambling statute, saying it was unconstitutional. They lost every one of them, and they lack standing in every one of them. So, treaty obligations, same thing. Doesn't, and we'll just buzz through this. Yeah, UIGEA loses. They appeal. Appeals court agrees with the district court. One, they don't have standing, and even if they did, the UIGEA is not unconstitutional. Jay Cohen. And I wish I could find the 60 minutes on Jay Cohen. That one just doesn't seem to be available. Jay Cohen actually was kind of interesting because he had an opinion from a boutique firm in Nevada from, I think, around 1999, 2000. I think it was 1999. Maybe it was a little earlier than that, actually. But the boutique firm really wasn't a gaming boutique. It was more of an IP boutique. But Jay Cohen works for a company called Group One in San Francisco, and they develop derivative trading software. Now, at some point, they realized, you know what, derivatives and sports wagers, from the point of view of a computer, pretty much the same. You put money down on a position that gets determined at a certain point in time. And if the outcome is favorable to you, you end up with more money. And if it's not, you lose your investment. Looks a lot like sports wagering. And so he and his buddies decide, you know what? We should just use our knowledge and create a sports wagering site. And they do. And they go down to Antigua and they start the World Sports Exchange. So 3 guys do this. I think it's a pretty good idea. And it gets pretty big pretty quickly. And FBI agents in New York eventually place telephone wagers and get online and place online wagers with the site. He and his buddies get indicted. Now they're in Antigua. It's an indictment, but anybody take criminal law? Can you prosecute somebody criminally in the United States in rem? No, you can't. You actually have to have physical custody of the defendant, of the accused. So as long as he's in Antigua, there's not much U.S. justice can do about it. But he returns to the U.S. for a wedding and actually turns himself in to fight the charges. Okay. And Well, what are his arguments? Well, he argues he can't be convicted on the conspiracy charges without a corrupt motive. In addition, he argues that those wagers were actually all placed in Antigua. They weren't placed in New York. They were placed in Antigua, and they're subject to the safe harbor provision in 1084B. He also said that he lacked the knowledge requirement of 1084A. And the rule of lenity should apply because the statute's ambiguous as it applies to the internet and his activities. And, the court amended the indictment, and worst of all, the court failed to permit a delay to take the deposition of a foreign witness. That foreign witness being somebody from the gaming regulatory body in Antigua that issued their license to him. So what does the court think of these? Well, with regard to having a corrupt motive, that doctrine doesn't apply to the Federal Wire Act. You don't need to have an evil purpose or corrupt motive to violate the Federal Wire Act. What about that safe harbor argument? Remember 1084A, the Wire Act, what it prohibits? Transmission in interstate or foreign commerce of bets or wagers or information assisting in the placement of bets or wagers at a sporting event or contest, or for the transmission of a communication that entitles the recipient to money or credits based on a bet or wager, or for the transmission of information assisting in the placement of bets or wagers. And then we have B. Remember what B had? There were two exemptions in B, one for news reporting and one for, anybody remember? Courtney.
I think this is where if it's legal in both the sending and receiving jurisdictions, there's an exemption.
Right, there's an exemption for the transmission of information assisting and placement of bets or wagers between jurisdictions where it's legal, not the transmission of the bet itself. This becomes important here because the court said, well, for 1084B, the safe harbor to be effective, the activity has to be legal at both ends of the transmission, and the transmission has to be mere information assisting in the placement of bet or wager, not the bet or wager itself. And he's got a problem here. Well, first of all, sports wagering is illegal in New York at this point in time. It might still be. That's another question. So that part doesn't apply because that type of betting has to be legal in both jurisdictions, and it's not in New York. What about the second part? What is information assisting? We talked about this a little bit. Anybody remember any examples of information assisting the placement of the bet or wager? Austin.
Like who's playing, who's scratched, things like that.
Yeah, exactly. It's the information bookmakers use to operate their books. So line information, point spreads, odds, scratches, things that the bookmaker uses to operate. And here, the government proved that they sent a signal from New York down to WSC to place a bet, and WSC accepted that bet. So this isn't information assisting. This is the bet itself. Now, his argument was, well, you're sending information to our bookmakers in Antigua. The bet actually gets placed between are bookmakers in Antigua and your account in Antigua, and all you're sending is information assisting. The court said no, that's actually the bet. Oops, let me back it up. So, and this is a good example of, that distinction between a bet and information assisting. If that information creates the bet, that's the bet. That's all part of the bet. What about the knowledge requirement? In criminal law, do you have to know what you're doing is illegal? Gee, I didn't know robbing the bank was illegal. No. You don't have to know what you're doing is illegal. All 1084 prohibits is the knowledge requirement just means that you knew you were transmitting bets or information assisting in the placement of bets. You don't need to know what you're doing is illegal. You just need to know what you're doing is covered by the statute. Or you just need to know what you're doing and that act is actually covered by the statute. You don't have to intend to violate the statute. Did you know you were transmitting bets or information assisting? Yeah. Did you know it was illegal? Doesn't matter. You just have to know what you're doing. Oh, lenity. Where there's grievous ambiguity in the statute, you can't really tell if what you're doing is illegal or not. Of course, it's supposed to be lenient, right? Not here. Again, this law was passed in 1961. There's a huge body of case law on it. Unlike the UIGEA, I've got 2 3-inch binders full of legislative history on it. There's a lot of legislative history. That's printed on both sides, by the way, and they are bursting. No. This has survived constitutional challenges in the past. It's not that ambiguous. So it's pretty clear what it covers. What about that failing to permit a delay to take the deposition of a foreign witness? Do you think somebody from Antigua's gaming regulatory body is going to come to New York for a deposition? Would issuing licenses to take illegal wagers in the United States be part of the business or betting or wagering? Would it be providing some kind of essential? Yeah. Yeah, they weren't going to take that chance. So, no. And what could that witness testify about? Well, Cohen said, well, you could testify about my corrupt motive and whether I thought what I was doing was legal. And the court said, we've already addressed both of those. It's irrelevant. You knew what you were doing. What you were doing was illegal. You don't have to know that it was illegal. So those issues have already been dealt with. The testimony that you would get from that witness is irrelevant. Government didn't have to delay. So Jay Cohen actually spent time in prison in Nevada, of all places. And he's out. Last I heard, his 2 friends said he can't come back to, being part of the business because he's a convicted felon. He's unsuitable. Buddies didn't give up the business. It's a great big world out there, right? So maybe you can't step foot in the United States. Well, there are lots of nice places. So what do you think? Jay Cohen. Austin.
So I just want to make sure you can only give information assisting if the gambling is legal in both states. So if it's illegal in one state, you can't even give information assisting, right?
Exactly. So, for example, William Hill who actually was Brandywine Gaming at the time, became William Hill, had operations here in Nevada. When Delaware brought back its sports wagering lottery, they did so in a way, I don't know if we went over this yet or not. We probably haven't. Delaware had a sports lottery back in 2000, or I'm sorry, back in 1976 and 77. But it lost money. They printed up bad parlay cards, they lost money, they shut it down. There was a law called PASPA that prevented states from authorizing gambling. That was deemed unconstitutional in 2017. But in 2009, Delaware brought back its sports lottery. But this time they were going to be smart. They weren't going to do the cards themselves. They were going to hire professionals to do it. And they hired Brandywine Gaming to do it, which became William Hill. And so Brandywine set up shop in Delaware. They couldn't print the parlay cards or send the parlay card information. They could send parlay card information, but they couldn't have the terminals in Delaware actually hooked up to the servers here in Nevada. Right? Because you got a Wire Act issue. That'd be the transmission of the bet. But they can have the folks here in Las Vegas create the parlay card information and transmit that to Delaware. That's information assisting, legal in both states. What they couldn't do is, let's say they had a client in or customer in Utah, transmitting that betting information to Utah, not legal in Utah, create a federal Wire Act issue. So it has to be legal on both ends. Does that help? Does that make sense?
Yeah, and then even if it is legal on both ends, you can never accept the actual bet.
Exactly.
Okay.
That's exactly it. Hit the nail on the head. And that gets misinterpreted by a lot of people, particularly foreign operators who just don't understand the distinction and don't understand the archaic nature of gambling laws in the United States, where it's primarily state and tribal based, not federal. In most places, you get a gambling, you go to the UK, you get a gambling license, it's good for the entire UK. You go to France, you get an online poker license, it's good for the entire country of France. Come to the United States, you get a gaming license in Nevada, it's only good in Nevada? You can only take bets in Nevada? I got a sports book license, I can only take bets from Nevada? Yeah. There are no national licenses. So it's a different mindset. And then that distinction between information assisting versus taking the bet is another one that it's difficult for foreign operators to understand, but it's there. Any other comments about Jay Cohen? So, can a U.S. company take online sports wagers legally? Sure. Do it here in Nevada all the time, right? Got plenty of competition. William Hill, Boyd, Wynn, all have online books. You can place bets online. It's just on an intrastate basis. Not interstate, but intrastate. So what about online casino gambling? This is where the Wire Act issues get interesting. Sure, you can. And this is WinBet. The question then is, can you take it on an interstate basis, or is it intrastate only? And that's why the Wire Act issue is such a big deal. It's for this kind of wagering. Because if the Wire Act only applies to sports wagers, then you could have an operator with a license in New Jersey and a license in Pennsylvania who only has to have one set of servers, either in New Jersey or Pennsylvania. And they can take bets from players in both states. Because if the Wire Act only applies to sports, this isn't sports wagering. Then you look at the Illegal Gambling Business Act, but it's not illegal under the state laws of those two states. But if the 2019 opinion is right, which doesn't seem to be the view of the DOJ anymore, but they're not explicitly stating that, then this would be illegal. You'd have to have separate setup in Pennsylvania, separate setup in New Jersey, just like you do for sports. But no, a US company can take online casino game betting as long as it's legal under state law and states are conducting it. Advertising online gambling. Well, if you advertise illegal online gambling, or if you represent a media company that allows that, you may face some action. This is a letter from the DOJ to advertise to the National Association of Broadcasters, telling them that if they take ads for illegal internet gambling offshore sites, that it's going to violate the Federal Wire Act, the Wagering Paraphernalia Act, and the Illegal Gambling Business Act. And this was out in 2003, and they started going out and enforcing it. It's in your materials. Not finish the slides for today, which if we don't, we'll finish up internet Wednesday, and then we'll move on to First Amendment Monday if we don't. This is a letter a client of mine received about that letter, from the Association of Broadcasters. This is in 2006. This client was a Men's Style magazine, and they had taken ads for online poker sites. And the Department of Justice sent them a letter saying, we subpoenaed your records, and after we looked at your records, we believe that you collected X million dollars in advertising revenue from offshores. And we want you to call about a settlement, or we're going to file charges against you. And your company. How much you make. Powerful letter. And they didn't want profits, they wanted gross revenue. Now, anybody ever work for a media company or work in advertising? You know what rate card is? Rate card is the retail price of advertising space. And almost nobody plays rate card. Like, it's unheard of for anybody to pay rate card. Online sites are paying rate plus because they wanted the exposure. But like nobody pays rate. So this was a big deal for magazines and newspapers and billboard companies and radio stations that were receiving those letters. Talk about a few other people. Peter Dix. Oh, pull up this. This worked yesterday, and it still works today. Well, except for it's got a paywall. Let's go to the next one. Share. Oh. I don't want to subscribe now. Peter Dix was a former banker. Anybody know what bankers do after they retire? High-level banking executives? They end up on the boards of directors of a number of companies. Lots of them. It's kind of like the victory tour. Peter Dix was a banker from the UK, retired, was on the board for a number of insurance companies, but he's also on the board of a company called Sporting Bet. And when he traveled to New York to attend a board meeting for an insurance company, he was arrested at JFK on an outstanding warrant from St. Landry Parish, Louisiana. Anybody know where St. Landry Parish is? Me either. No, I did look it up on the map. It's not too far from New Orleans, but it's certainly not a booming metropolis. And what the prosecutor in St. Landry Parish did is he saw their public documents, their investor documents, and he indicted everybody mentioned in there. So he gets nabbed at JFK, and there was a defect in the warrant. So the prosecutor of St. Landry Parish contacted New York officials and asked them to hold Mr. Dix while the defect was corrected. Governor Pataki in New York decided, I'm going to do that. So what do you think Mr. Dix did? If you were Mr. Dix, what would you do? You've just been arrested, but now you found there's a defect in the warrant, so you're not arrested, and the Louisiana State Police want to correct the defect and reissue it. What would you do? Courtney?
Flee the country, maybe?
Yeah, exactly. You get on a plane and you head right back to London. And that's what he did. Stop that share. Oh, whoops. We'll go to the next one. And then what would you do after that? Oops, I lost my Zoom piece here. Share. Well, he went right back to the UK, and then he promptly resigned from the board of Sporting Bet. Who knows where else he might fly to and get arrested? Now, is Peter Dix, real familiar with sports wagering and things like that? He's a banker. I mean, that's what public companies do. Your board represents large stockholders that usually have somebody from banking, somebody maybe from insurance, former insurance executive on the board. You try to get former politicians or relatives of politicians, so you have some political clout as well. But he left. He got out. By the way, he eventually came back in after Sporting Bet was stopped taking bets from places like the United States. Let's get back to PowerPoint slideshow. And David Carruthers. David, really good guy. I like David personally. David was an executive at a company called Ladbrokes. Ladbrokes was a large bookmaker in Europe and the UK. And he left Ladbrokes to join a startup called Bet on Sports. Bet on Sports had its headquarters in the UK, but all its operations were out of Costa Rica. And David Carruthers would frequent gaming conferences. I don't know if anybody's ever, well, pre-COVID, there was probably a gaming conference a month. I mean, if you're practicing a gaming law, there was always an opportunity to go to some kind of conference somewhere on gaming. But he would show up and he would talk about Bet on Sports and the archaic laws here in the United States and how they don't make any sense and they're not enforced anyway. And he actually did a debate with, I think it was Congressman Leach, about US sports betting laws. Now, Bet on Sports, again, operates out of Costa Rica. They went public on the AIM Stock Exchange in London, in the UK, I'm sorry. And their primary market was the United States. In fact, they would have buses, like the big buses, that would show up to football stadiums, NFL stadiums. The side of the bus would fold down and there'd be all these tables with computers on them. And they had attractive cheerleaders that would run out of the bus and attract people to come over. And they could set up their accounts. They could start betting right then and there, just outside the stadium. And they were really brazen about this. And again, he was showing up at conference after conference. And I remember being at a conference and you know, he's debating this, he's on a panel. And one of my clients was with me, he's like, where's the FBI? You know, this guy, can't believe this guy's not getting arrested. Well, eventually he did. He was flying from London to Costa Rica, San Jose, Costa Rica. And he's flying BA. And BA is part of, was it the Global Alliance? Anybody familiar with? Anyway, British Air is part of a group of airlines that code share and things like that. And they code share with American Airlines. Now, there's no direct flight from London to San Jose, Costa Rica. So you have to fly from London to Dallas, Fort Worth, and then from Dallas, Fort Worth down to Costa Rica. And while he was changing planes at Dallas, Fort Worth, he gets picked up on an outstanding warrant. His wife is let go. He is charged. And he's sent off to the Eastern District of Missouri, where those letters came from, the National Association of Broadcasters, to stand trial. And he ends up getting 33 months of jail time. Gets convicted on 1955 and 1084 illegal gambling business act and federal wire act charges. Also schemed to defraud by mail. They used to send out mailers. Tax evasion, because again, Bet on Sports wasn't paying any taxes. They weren't issuing W-2Gs. They weren't paying taxes in the United States, even though they're making money here. And he kind of becomes the poster child for enforcement against offshores for online gambling. So let's pull up, we don't really need to pull up those sites. Now, at the same time, he got arrested. There were a number of conferences that were set to happen here in Nevada. And one was for Bovada. We're familiar with Bovada. They're an online, or Bodog. It's an online gambling site, very popular at the time, operated, I think at that time, out of the Kanawaki. And they were going to hold an affiliates conference at Wynn. And then they postponed it. And Calvin Ayre, the guy that was, you know, the face of Bodog, said, we're not afraid. We're still holding it at Wynn. We're just delaying it for administrative reasons. And then they canceled it at Wynn and decided to hold it in the Caribbean. and advised their affiliates who were attending to not travel through the United States. Take connecting flights out of Mexico, South America, whatever you have to do, but don't travel through the United States. And this is a big deal. This is a really big deal because Bet on Sports had just done its public offering, and they were effectively done after this. The CTO Party Gaming. We talked about this a little bit. Let me pull this out. Well, and this worked last night. It still works. And new share. So the CTO for Party Gaming, partypoker.com, was indicted on Wire Act charges for his role in party gaming. Let's pull this up. Are you seeing the Southern District of New York document now? Good. Ultimately, again, look at the date of that document. It's 2008. He pleads guilty to violating the Federal Wire Act for his role in party gaming, which is primarily, again, party poker. It's a poker site. The plea was accepted in 2010, by the way. And then in 2011, you get the new Wire Act opinion, which says poker is not the subject of the Wire Act. But right up until 11 months before that opinion, the Department of Justice was taking pleas for poker sites on online gambling. So let's flip over to the charging document for him. And I apologize. I just don't know how to pronounce his name, and I'm sure I would butcher it. So, and not intentionally. So again, from 97 to 2006, this company operates out of Gibraltar, and it offered casino and online poker games, among other games of chance. The offense, Title 18, Section 1084. That's Wire Act for poker and casino games. Again, on December 16th, the plea agreement was finalized and accepted. Court accepted it. And he doesn't serve any jail time. He forfeits $300 million to the DOJ, agrees to cooperate with the DOJ, and all is good. Don't feel too bad for him. He does live in a multi-story house that looks like an office building with a helicopter pad on the top. He's still doing okay. 300 million didn't hurt him that much, apparently. And really who they were really after was Ruth Parasol and Russell DeLeon, or DeLeon. Now, Ruth Parasol, when Party Gaming did its initial public offering in 2005, she was encouraging people to invest in it, even from the US. And the Department of Justice said, don't do it. It's illegal. And she was on the front page of the Times, London Times, saying it's not illegal. If it was illegal, we would have been arrested long ago, and we travel the United States with impunity. The Department of Justice was in the paper the next day saying, well, it is illegal, and we encourage you to come back to talk about it. She didn't come back. So, you know, he avoided jail time, but they were really after the big folks. We can finish this up, I think, today. Antigua, WTO, GATS. Antigua went after the United States through a WTO action. The Bush administration never replied, didn't think it was worth a reply. And Antigua won $20 million worth of sanctions against the United States. And they can take it out in the form of not paying copyright royalties to copyright holders in the United States. Anybody care to guess why they would do that? Why they would take it out in IP? Well, they're trying to leverage IP companies, content makers in the United States to pressure the federal government to allowing online gambling in the United States. They thought Disney would be upset with this. And in fact, they announced that they would begin selling Disney movies royalty-free out of Antigua. Nothing much came of it, though. I mean, it's $20 million. It's like, okay, so we got a trade war with Antigua. Okay. Nice place, nice people, but it's probably not one of our top 10 trading partners. So it kind of went nowhere. We talked about this a little bit already, but in 2009, the lotteries get involved with online, and they send a letter to the DOJ saying, we want to sell online lottery tickets on an intrastate basis, but using an out-of-state processor. We don't think it violates the Wire Act, but if it does, let us know. We won't do it. DOJ kept silent. They didn't do anything. Enter the senators, that letter from Reid and Kyle, who were not on the same side of the aisle in the Congress, but were on the same side when it came to online gambling. They wanted the DOJ to issue an opinion saying, Wire Act still applies, New York, Illinois, you can't do what you're doing. But that was so that they would support the online poker bill that Reid and Kyle put together that would allow them explicitly to do what they were doing. Again, 2011, DOJ opinion comes out. 2019, new DOJ opinion comes out. 2020, shot down. 2021, no appeal. And we have sort of an opinion issued out there that has been knocked down in New Hampshire, and only New Hampshire. And now we've got IGT that file an action, and I think in Rhode Island, to try and expand that. And we did finish it. A little bit late, but better than. So we can move on to First Amendment on Wednesday if you want to. Questions? Hearing none, I know other people have classes to go to, so enjoy. Thank you, and Wednesday, First Amendment.